Hello, my name is Major Mike Webb, and I am an independent candidate for state delegate in Virginia's 3rd House District in Arlington and Alexandria, Virginia. But on Friday, March 24th, I will be in Chesterfield County, Virginia, due south and just across the Charles River from Richmond, in what will be the first case in history to compel a grand jury investigation into a pandemic-related death from other than natural causes. This case is coming up for hearing at a very interesting time in which the Congress is holding hearings regarding COVID-19. And while the debate regarding the origins of the novel coronavirus have once again returned to headline news, with galvanized support for what has, throughout 3 years of pandemic, been considered a fringe or even crackpot conspiracy theory involving a laboratory origin, which several notable persons in the scientific community have rejected flat out of hand. First, for a little bit about myself and my background to provide some context for this litigation. Although I was the son of a black pastor in a family line of black Baptist pastors, and even have 2 family churches on the National Historic Registry, I also had the privilege to be a childhood protege to the legendary criminal defense and civil rights attorney Raymond A. Brown, a very close friend of my father. And so I have been in courtrooms since grammar school and in high-profile cases. Before transitioning into the commissioned officer corps, where I had been assigned to strategic counterintelligence, I had served in an enlisted capacity as a battalion legal specialist in the elite 75th Ranger Regiment, an elite light infantry unit that draws less than 1% of the active duty Army. And in the late 1990s, I had the privilege to play a key staff role in essentially standing up a NORAD-type capability to address emerging public health threats and biological terror, which may appear to be the same on first presentation, because biological warfare provides a first strike capability, exploiting the critical element of surprise through what is often termed as plausible deniability. Noting what appeared to be striking inconsistencies, at least for an intelligence analyst, in the accounts regarding the infection and death of Bishop Gerald Glenn early in the public health crisis, I had decided to present an affidavit to the Commonwealth Attorney in Chesterfield, Stacey Davenport, which is an authorized procedure for a competent witness to commence a criminal investigation or issue of what is described as an information, which is akin to an indictment without a grand jury. However, failing to find that office taking action after submission of that affidavit, as prescribed by law, I had resorted to a legal procedure described as a writ of mandamus, a term that some may recall from study of American history in the landmark case of Marbury v. Madison at the beginning of the Republic. And the courts have said that this legal procedure is available when there is no other adequate legal remedy, and therefore to prevent a failure of justice. However, there are some very important rules that apply. The public official has to possess a mandatory duty without discretionary authority. And under the Virginia Code, it is the mandatory duty of a Commonwealth attorney to prosecute felonies, or a ministerial duty, as is often said in court cases. Moreover, this remedy is distinct from a legal defense of necessity and is not available to just anyone or at any time during which there appears to be an injustice, but rather, in a rule of law, as Justice Harlan had stated in the smallpox vaccine case, Jacobson v. Massachusetts, no power can be exerted to that end by the United States unless it be found in some express delegation of power or in some power to be properly implied therefrom. Commonwealth Attorney Davenport has filed what is described as a plea in bar, asserting that she has prosecutorial discretion, which would be true under the Virginia Code for crimes classified as misdemeanors. However, the controlling statute clearly and explicitly provides that a Commonwealth attorney not may, but shall prosecute felonies, which attorneys and courts have consistently described as mandatory language. And I believe that a quick review of the facts involving the infection and death of Bishop Glenn raise at least a reasonable level of suspicion, which has been recognized by the Supreme Court as sufficient to warrant a Terry stop, or conduct that is sufficient to suggest that criminal activity may be afoot. And particularly for government officers in U.S. v. Lutheran, the court had held that while mere knowledge of criminal activity is insufficient to hold an officer culpable of wrongdoing, it is quite different if, as in this case, under the law, there is also a duty to act, and where neglect of that duty by an officer would be found to be aiding and abetting the conduct of the wrongdoer through that failure to so act. As an intelligence officer, you will probably spend a few months at Fort Huachuca, Arizona, just looking at military maps and beginning to understand the process described as intelligence preparation of the battlefield, or IPB, where you may begin the intelligence planning process with what is generally known about the enemy through doctrine, which may be dictated often by equipment capabilities, such as ranges for artillery pieces or terrain. But you will quickly find that when you place that acetate overlay on the map to describe the doctrinal order of battle for the enemy, placement of battle assets, terrain obstacles will frustrate that plan. You don't want to have a tank in the middle of a lake or an artillery piece. And just as the enemy wouldn't be the enemy if they always acted in accordance with your plan, we often say that no plan ever survives first contact with the enemy. And that is where our intelligence analysts go to work to attempt to develop and refine a clearer picture of the threat based upon reports from the field, and intelligence drives the mission cycle. In pandemic, we have gone through some general ideas about how many things should occur by general science, how things should evolve, how things should react, which you may have heard often in arguments and which have been the subject of many generalized metadata analyses, which help to give you perhaps sometimes coincidental correlation, but not necessarily causation. And however, for the eyes on the objective, boots on ground perspective, you must supplement that study and research with spot reports, which we find most often in science in various case studies that have informed us better about how this adversary attacks in very specific situations and under particular conditions. And that is important for understanding the true nature and capabilities of the threat. So let's, in the time remaining, just take the time to refine the picture of the threat as it was presenting in Chesterfield when Bishop Glenn, his wife, 2 daughters, and his son-in-law had been infected. As early as January 2020, there were events described in a case study that presented what had been described by some as a super spreader event that had occurred in China in Guangzhou, and involving a man who had traveled there from Wuhan, 614 miles away, with members of his family, a 2-day journey, but he had failed to infect anyone else on that train and did not appear to infect anyone until he had been seated in a 3rd floor dining room that measured 145 square meters. And that simply does not sound at all like a highly contagious disease. Coincidentally, at least in that case study, the parameters provided for the affected area exactly match the effective range of a standard smoke grenade, or 30 square meters, raising a reasonable inference of suspicion. And all persons who were infected in that small area had shared potential exposures for up to an hour, while even restaurant staff who simply moved through the target area failed to sustain an infection. That tells at least an intelligence analyst something about this virus and its ability to attack. By February 2020, there was a robust boots-on-ground effort consisting of 1,800 teams of at least 5 epidemiologists, and they provided a very clear picture of the outbreak in China, informing us that the consistent pattern of infections had appeared in discrete clusters tied to a specific location and with no wider community spread, a significant finding that has appeared throughout variants, the original through Delta and even into Omicron, for this virus, which would not be typical of a disease being transmitted from person to person. However, most importantly, they provided us with a number, a metric of transmissibility risk known as secondary attack rate, standard rate, not reproductive number, which they assessed at between 0.9 and 4.8%, depending upon location, and location. And if, as they say, there was a cluster of cases at the wet market, that would suggest to an intelligence analyst, especially based on this information, that there may be something remaining at that location that was the cause. Because a communicable disease is going to attach itself to a human host and go wherever they go, presenting a sprawling pattern of infections enhanced by the time-fused delay of an incubatory period before a patient even knows that he or she has been infected. Ophthalmological attorney Davenport has filed a plea in bar asserting a prosecutorial discretion claim. We have filed a counter motion for summary judgment, in which the standard is that if there is no genuine issue arising from a material fact, then the movement is entitled to relief as a matter of law. And I believe that when the evidence on the ground in Chesterfield is examined, including the fact that Bishop Glenn had no known comorbidity factors, his aberration from even what is known regarding the illness timeline after infection, which most cases resulting in complications tend to become terminal in just 8 days, while cases involving recovery tend to move to remission within just about 20 days, while he apparently was hospitalized and 3 days later was in a fatal case. But also the intriguing fact that he and 30 other Black Pentecostal faith leaders had not only been infected, but also had succumbed to COVID-19 before Easter. There is sufficient evidence to validate what had been determined in case studies about this virus, which appears to have little or no independent transmissibility risk, prompting the express conclusion by the WHO in February 2020 that it is not clear whether this correlates with the presence of an infectious virus. And I might add that it appears that this Oswald shooter coronavirus could only have been deployed against Bishop Glenn and probably others. And this is the case that we shall be presenting to the court in Chesterfield on March 24th. My name is Major Mike Webb, and this briefing is unclassified.